Greetings from Tokyo. I am Komoto Mayumi, an attorney at the Litigation Bureau of the Ministry of Justice of Japan. I'll be acting as a program moderator today, and it is my great pleasure to welcome you to this special event for the Ministerial Forum on Justice Affairs Diplomacy. Without further delay, let us proceed to the opening remarks. They will be delivered by the Director General of the Civil Affairs Bureau of the Ministry of Justice of Japan, Mr. Kaneko Osamu.
Good morning, good afternoon, and good evening, everyone. My name is Kaneko Osamu, the Director General of the Civil Affairs Bureau of the Ministry of Justice of Japan. I would like to thank you all for your participation today in the special event entitled The Future Prospects of International Arbitration and Mediation. How does the Judiciary assist? Held alongside the Justice Affairs Diplomacy Ministerial Forum. I would also like to thank the distinguished keynote speakers and panelists for their cooperation in organizing this special event, as well as the members of the East Asia branch of the Chartered Institute of Arbitrators, the Japan Association of Arbitrators, the Japan International Dispute Resolution Center, the Japan In-House Lawyers Association, and the Supreme Court of Japan for their support. As you know, when a legal dispute arises, there are generally two ways to resolve the dispute through the involvement of a neutral third party: litigation and alternative dispute resolution, ADR. Although in some respects, it is not easy for the government to take the initiative in promoting the use of ADR conducted by private organizations, the Ministry of Justice has been providing information on ADR, promoting online ADR, and supporting ADR organizations' activities, such as holding symposiums to exchange information and strengthen cooperation. In addition, in recent years, there have been more calls for efforts to broaden the base of international legal human resources and to promote international arbitration in Japan by raising awareness of the value of using it among domestic and foreign companies, as well as in-house lawyers. In response, the Ministry of Justice and other relevant ministries are cooperating with the private sector to improve the environment, including arbitration-related legislation. The establishment of JIMC Kyoto by the JCAA and the establishment of JDRC Osaka can be regarded as the private sector activities following this trend. This special event is co-hosted by the Ministry of Justice and the Japan Commercial Arbitration Association, the largest commercial arbitration organization in Japan. The JCAA is presenting a congratulatory speech by newly appointed President Mr. Kitagawa Shinsuke, and is also introducing its initiatives in the keynote speeches and panel discussions. From the Litigation Bureau of the Ministry of Justice, the Director General, Mr. Haruna Shigeru, is introducing the international endeavors of the Bureau to further develop international arbitration and mediation, including information on the latest trends of UNSTRAL. The International Affairs Division of the Minister's Secretariat of the Ministry of Justice is providing an exhibition on Japan's latest ADR initiatives and expertise in the foyer, together with the JCAA and the JDRC. A briefing session will take place right after this special event, so please stop by on your way back. Now to tell you a little about the efforts of the Civil Affairs Bureau. 3 bills on private ADR passed in this year's regular session of the Diet. Those bills are intended to integrally strengthen ADR procedures in line with the latest international standards in order to further promote the use of ADR and to achieve a prompt, appropriate, and effective resolution of disputes. Specifically, the new acts will enable the enforcement of arbitral tribunals' orders of interim measures and settlement agreements through mediation under the Singapore Convention on Mediation. Furthermore, the acts allow Japanese courts to omit the submission of Japanese translations of arbitral awards and settlement agreements in the proceedings for obtaining execution orders in Japan, and include the expansion of jurisdiction to Tokyo and Osaka district courts. I would like to point out 2 major perspectives of this special event. The first perspective is to increase the efficiency of private ADR through the combination of arbitration and mediation. In recent years, for example, mediation arbitration procedures have been used as a method of resolving international disputes in which mediation is conducted prior to the commencement of arbitration or during the process of selecting arbitrators. And if a settlement agreement is not reached there, the case proceeds to arbitration. These mixed processes can be said to enhance the overall dispute resolution function of ADR by consciously seeking settlement agreement. The second perspective is to enhance ADR by judicial involvement. The key element of the before-mentioned 3 ADR acts cannot be effective by the actions of the private sector alone, and the involvement of the judiciary is essential, such as court review of international settlement agreements for their enforcement. Based on these 2 perspectives, I hope that the discussions on better ways to resolve international disputes among people from various backgrounds will lead to strengthening the rule of law, which is the main theme of the Justice Affairs Diplomacy Ministerial Forum. Last but not least, the Diet of Japan approved the Singapore Convention on Mediation last month. I'm deeply pleased that we can seize this opportunity to promote the bright future of private ADR with particular emphasis on the value of mediation, which is a preferred method of ADR in Japan. Thank you very much.
I thank Mr. Kaneko for his remarks. Next, we will proceed to the ceremonial address by the Minister of Justice of Japan, Mr. Saito Ken. As you may know, he is currently hosting the ASEAN G7 Justice Ministers interface of this forum. Therefore, his ceremonial address is pre-recorded.
I would like to extend a hearty welcome to everyone participating in this special event. Resolving disputes in a fair and reliable manner is the cornerstone of the rule of law, which is also the main theme of this Justice Affairs Diplomacy Ministerial Forum. International arbitration and mediation, along with the judicial system, are key elements of dispute resolution in civil and commercial matters. The joint statement of the ASEAN-Japan Special Meeting of Justice Ministers adopted yesterday expresses political will to strengthen our cooperation in promoting rules-based resolution to disputes through use of alternative dispute resolution mechanisms, such as arbitration and mediation. Under the New York Convention, an international arbitration award is easily enforceable in cross-border cases, and under the Singapore Convention on Mediation, which has recently come into effect, international mediation is becoming increasingly user-friendly. It is important that we strengthen these legal frameworks in which the outcomes of international arbitration and mediation are reliably implemented in Asia and Europe and on a global scale. In April of this year, Japan enacted, ahead of many other countries, the implementing bill of the Singapore Convention on Mediation. Also, Japan has updated the Arbitration Act to meet the most recent NSREL model law. Japan has also been committed to the formulation of international dispute resolution rules by participating in the drafting process of legal instruments at relevant international conferences. Furthermore, based on a proposal from Japan, at NSREL, a project named Stocktaking of Developments in Dispute Resolution in the Digital Economy is currently underway. Through these undertakings, the Japanese government has been and will be contributing to the creation of legal schemes for international dispute resolution. I hope that this special event will deepen your understanding of the value of the strategic and effective use of alternative dispute resolution proceedings. Thank you.
I thank Minister for his address. Next, we will proceed to the congratulatory speech by the President of the Japan Commercial Arbitration Association, JCAA, Mr. Kitagawa Shinsuke.
Good morning and good afternoon, distinguished colleagues. It is a great pleasure for us to welcome many judicial, arbitration, and mediation officials from the ASEAN and G7 countries to this special event. Welcome to Japan. So, our world has faced unexpected challenges like the COVID-19 pandemic and the international conflict across the countries. Additionally, advancement in technology, such as AI, have changed our society. Under these circumstances, disputes between companies are growing in various forms across national borders and become more and more complex. In this situation, it is important for arbitration institutions like ours to help business resolve their dispute quickly and flexibly by using our agility, diversity, and expertise. In Japan, the Japan Commercial Arbitration Association, the JCAA, has expanded the automatic application of expedited arbitration procedures in both in standard commercial arbitration rules and its unique and innovative set of rules, the interactive arbitration rules. It is also providing an easy-to-use and efficient arbitration and mediation system through the active use of online filings and conferences that can flexibly respond to the need of the partners beyond the pandemic. So, the Japanese government has also made effort to revitalize international arbitration as one of its basic policies And recently, legislative reforms have been made to strengthen the legal framework for both arbitration and mediation. The Japanese courts have also accepted arbitration as an effective alternative dispute resolution infrastructure and are actively and appropriately supporting it in their decisions. I hope that the government, including its judicial and legislative branches, will continue to focus their efforts on development, improvement, and promotion of laws and regulations that support arbitration and mediation in Japan. So, for our part, as arbitration and mediation institutions, we must evolve with the time and keep on making further effort to function well as trusted vehicle for prompt and cost-efficient dispute resolution services. So I look for the lively exchange of ideas among all those involved in the judiciary, arbitration, and mediation sectors, as well as the opportunity to learn the latest trend and information from around the world. We are in the same boat. Thank you.
I thank Mr. Kitagawa for his speech.